Good afternoon. Welcome to MazzaMedia. It is Monday, February 9th, 2026. We are live here on YouTube today, ready to discuss the latest Kelsey Fitzsimmons news. And there's news coming out today. There was a hearing, obviously. There was, as I adjust my camera a little bit. Hope you guys are doing good. Britt happens, what's going on? Tracy, how are you? Casey, good afternoon. Jen, how are you? I always like that picture there. That's a good one. It looks like you're at the zoo. But yeah, Kelsey Fitzsimmons news here today. We're going to go over all of this. We're going to touch base on exactly what's going on out there and what's happening. And yesterday I did get some information early in the day that was brought to my attention that Kelsey Fitzsimmons' defense team was going to file a motion to recuse Judge McCarthy-Neyman, which was, happened this morning. And no kidding, Jen, you're in Mexico right now? That's awesome. Hopefully it's nice and warm there because it's freezing in Massachusetts right now. Hey, Dor, how are you? Becky, how are you? Joelle, good afternoon. But yes, I was actually pondering going today. I have today off. I always take the day after the Super Bowl off, and I usually take the day after the Super Bowl off because I'm extremely exhausted after the Super Bowl. And Feminem's in the house. What's going on, Feminem? Hope you're doing good. Usually I'm exhausted the next day, and so I set my alarm for 6 o'clock. And, you know, it wasn't just a Super Bowl yesterday. It was a Patriots Super Bowl. And sure enough, 6 o'clock, the alarm goes off, and I'm like, I don't think I'm going to be able to make it. And then, you know, when I heard the hearing was only so long, I was like, okay, it was, you know, I'm like, what are you going to do? I'm planning on being, being at the trial at least one time is my goal. I'm just going to wait until that day is set, just in case there's any delays with what's happening. So, we'll see. We'll play it as we go and see how things go. Britt happens. Looks like you just changed your picture. Nice picture there. Definitely tired. Made lots of snacks. That's good. Yeah, those steak and cheese stuffed peppers were awesome. They're always a hit when I make them. I grab steak shavings, saute mushrooms and onions, then the steak shavings, cook the peppers in the oven, and then load them up. And then this year, usually I do American cheese. This year I did pepper jack and cheddar just to mix it up a little bit, change it up. And they were a hit. The pepper jacks were the bigger hit, bigger than the cheddar, quite honestly, were the bigger hit. Then, of course, there were the barbecue wings and the garlic parmesan wings. The garlic parmesan wings were the bigger hit of the wings as well. So usually I thought the barbecue would be the bigger hit, but the garlic parmesan was the bigger hit. So, yeah, it was fun. It was fun. It was a fun Super Bowl party. It just was not a fun Super Bowl last night. Of all the Patriots Super Bowl losses, and I do not remember the first one, this one bothered me the least just because I know that this Patriots team has a huge upside and a good future with Vrabel and Drake May. And I know they're going to make some adjustments here going into next year. So, again, just exhausted today. And I didn't really start moving around to like noontime, to be honest with you. I had breakfast at like 12:30 today. Okay. If that tells you anything, it was an exhausting day. But catching up today, I have not read the motion to recuse. I'm going to read that today. We're going to go over that. We're going to discuss some of our opinions on this as well. And I'll look forward to some of the chat commentary on what you guys think. But a lot of the stuff, I'm kind of like half 1 foot in, 1 foot out with the news today. So I caught up on the hearing being very short today. I saw the picture of Kelsey and her family and a nice young woman that had a picture taken with Kelsey. Very nice picture. Kelsey's looking very good. She looks strong. She looks upbeat. But this is a tough situation to go through, obviously. Nobody wants to see anybody ever go through this. But I think Kelsey's putting her family are putting their best foot forward to move forward. And I think the defense team filing this motion to recuse against this judge, we're asking this judge essentially to recuse herself, was the right move because there's obviously a lot of issues with this judge. We're going to dig into it. I've essentially read the Spark Notes this morning that Meredith, who operates the Facebook group, posted. So we're going to dig into that as we go along today. And yes, I've heard some things as well, Jen. That's absolutely a fact. yes, if you guys would not mind liking this stream to push it out, I appreciate that. We're trying to spread the news. I see Andrea Burkhart was talking about this case on Twitter. That would be great if she could start covering this too. I know she says she's not yet, but if this can really, a lot of those real big YouTubers, attorneys, if they, like not the lawyer, Brother Counsel today covered it. We need like as many attorneys on YouTube to start pushing this stuff out as much as possible just to get it, make it a bigger story that it deserves to be. I think the story deserves to be just as big as the Karen Reed case. I truly do. There's a lot of controversy here. And again, a judge that not too many people are trusting right now, if anyone, quite honestly. Who, if anyone, is trusting this judge right now to steal from Lally? But yes, I mean, this is a story that deserves a lot more amplification than it's getting. I'll just continue to do the part I can. I can only do so much, obviously. We all individually can do so much, but when more people get involved collectively, it will only expand the story more. So thank you so much to everybody that's sharing the stream right now, sharing this story. There's links in the chat as well to the Facebook group. The GiveSendGo is out there as well. If you want to make a donation, please do to help Kelsey. Our next fundraiser will be Sunday the 15th at 2 p.m. I don't have to worry about football anymore, so we can pretty much just do the afternoons a lot more for Kelsey fundraisers. So 2 p.m. right now. Britt Happens, I believe Britt, you said you're going to be able to join that. So we'll have Britt Happens, and then Lauren Katie will more than likely be there. And then I'm going to reach out to a few other people, including some attorneys as well, and some familiar faces. Have a big show Sunday. We'll try to raise more money for Kelsey to help her out. Britt Happens confirmed she will be there at 2:00. That's great news. Always good to have you, Britt, on the show. And thank you for that, Britt. And all right, here we go. So let's start talking about this motion today. And again, a special show for me today. I have today off, and I have an opportunity to talk about this in depth today. So here we go. Let's start going through the recuse. All right, so this is the Commonwealth versus Kelsey Fitzsimmons. This is the defendant's motion to recuse Judge. Let me actually just step back for a sec. Can everyone just let me know, is this font size good enough for you? Just want to have everybody confirm. Oh, KY Maverick's in the house. What's going on, sir? All right, he goes, I can't believe the judge wants an evidentiary hearing. Hopefully she will recuse herself. And hopefully this font size looks pretty good to me. If it's too small for anybody, just let me know. I'll give everybody about 10 seconds to comment if it's good or bad. Just like to get an idea of how the chat feels before we do this read along today. And we'll give it 5, 4, 3, 2, 1. All right, we'll continue with this font size. She says, Kelsey will win, says, if I can see it, it's fine. There we go. Excellent. KY Maverick also says it's fine. KY Maverick's a good guy as well, folks. He has a lot of coverage on Kelsey Fitzsimmons on his Twitter page. Look him up on Twitter. He's a very good advocate for Kelsey, and give him a follow. Follow Britt Happens as well on Twitter. Really good coverage there of Kelsey and advocacy. And, of course, Jeno, one of the great mods here. Give her a follow on X as well. Love Jeno. Really great person, great mod for me. And she passionately cares about all these cases. Perfect. You can zoom in on your phone. That's good. All right, here we go. All right, let's start this read along here and start digging through the news. All right, so this is the defendant's motion to recuse Judge Kathleen McCarthy-Neyman in request for evidentiary hearing. Introduction. Now comes the defendant, Kelsey Fitzsimmons, by and through counsel, and hereby follows the instant motion to recuse Judge Kathleen McCarthy-Neyman. As grounds, it is apparent that a reasonable disinterested observer, being apprised of the facts of the judge's involvement in the case, would conclude that there is a lack of impartiality, or at a bare minimum, an appearance that the judge's impartiality might reasonably be questioned. So I immediately reflect back. Mullen Law's in the house. Mullen Law, hope you're doing well today. Again, Mullen Law, follow Mullen Law on Twitter. She's a fantastic attorney and has a very much big interest in the Kelsey Fitzsimmons case as well. But yes, this is immediately bringing back vibes of Judge Beverly Cannoni and her behavior that I thought, she should have recused herself as well, but that never happened. There was some controversy before the first trial even happened, honestly, but she refused to recuse. All right, so here we go. The instant motion is made pursuant to the Due Process Clause of the 14th Amendment of the United States Constitution, Article 29 of the Massachusetts Constitution Declaration of Rights, the provisions of the Supreme Judicial Court's Code of Judicial Conduct, and applicable case law, all of which mandate disqualification when a judge cannot be fair or impartial, or where her impartiality might reasonably be questioned by a disinterested third party. Here the record demonstrates multiple grounds, each independently sufficient and collectively, come on, Mark, you can get this word, dispositive, there we go, requiring recusal. All right, some big words, big word right there, big word. All right, just one quick second, folks. All right, sorry about that. All right, Britt says, typically, if a judge has been asked to self-recuse, that judge should do in order to avoid the appearance of impropriety. Struggling with my words today. Come on, Mark. Do better. Do better. Up your game. Impropriety. There we go. All right. Okay, here we go. Request for evidentiary hearing as the body of evidence required to be amassed in support of the motion likely includes, but is not limited to, probation officials, municipal third-party records, social media information, and the like. An evidentiary hearing and its attendant subpoena power is necessary to introduce the evidence and make sure the record is clear. Now, again, there's going to be some information that I've already heard about that's going to come up here that's really going to make a heck of a case for why this judge should recuse herself. And again, I've read some of the Spark notes on this. Applicable standard. A judge must disqualify himself in any proceeding in which a reasonable person, knowing all circumstances, would question the judge's impartiality. The inquiry does not turn on the judge's subjective belief in his own neutrality, nor does it require a showing of actual bias. This principle of impartial justice is enshrined in Article 29 of the Massachusetts Constitution Declaration of Rights. It is essential to the preservation of rights of every individual, his life, liberty, property, and character, that there be an impartial interpretation of the laws and administration of justice. It is the right of every citizen to be tried by judges as free, impartial, and independent as the lot of humanity will admit. Quote, a rigid adherence to that principle is essential to the maintenance of free institutions. It may never be relaxed, as quoted there. In fact, litigants and visitors of the Supreme Judicial Court at the John Adams Courthouse in Boston are greeted with one legal principle, to the exclusion of all others. In the vestibule, oh, goodness gracious, they're throwing some words at me today I can't pronounce. My goodness gracious, folks. Let's try it here. In the vestibule. Okay, hopefully I got it. My goodness gracious. The words of Article 29. I always get a little embarrassed when I can't read some of these words. My goodness. All right. We'll do the best we can. All right. The protection of an accused right to an impartial adjudicator is prominent in both the United States and Massachusetts constitutions. I'm going to skip anytime it starts to read, show this stuff. All right. Boom, 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 boom. All right. Quote, actual impartiality alone is not enough. Our decisions and those of the Supreme Judicial Court have commented often and in a variety of contexts on the importance of maintaining not only fairness, but also the appearance of fairness in every judicial proceeding. All right. In other words, an accused's constitutional right to due process demands that justice satisfy the appearance of justice. In ruling on a motion seeking recusal for an actual, apparent, or potential transgression of Article 29 and the Code of Judicial Conduct, a judge must, quote, consult first his own emotions and conscience. If he passes the internal test of freedom for disabling prejudice, he must next attempt an objective appraisal of whether this is a proceeding in which his impartiality might reasonably be questioned. If the answer is positive, the judge must grant the recusal motion regardless of such consequences as trial delay, which are immaterial. All right. This talks about the Code of Judicial Conduct. A judge shall disqualify himself or herself in a proceeding in which the judge's impartiality might reasonably be questioned. Emphasis added to that. All right. So they're really getting, thank you, Britt Happens. I appreciate it. And I like this comment here. Alice in Wonderland says, the appearance of bias is enough. Gino says, the appearance of impartiality is the big thing. The judge can claim no bias all day long, but what really matters is how it looks to the disinterested public. I agree as well. A quick drink of water here. Britt Happens says she ran a public poll on Twitter X about the public view of Judge McCarthy. I remember this one. The public view of Judge McCarthy's level of impartiality. The results stated she should excuse herself from this case. We're well into the 90th percentile. Dennis Sweeney's in the house. Dennis, hope you're well. Say hi to Brenda for me as well. Hope you guys are doing great. Tough game last night, but we'll move forward. Patriots got a good future in the next couple of years, so we'll be good. We will be good. Yeah, it's just, like I said, I like how they're really honing in on the judges here. Need to recuse herself. All right, continuing. A judge is disqualified from any matter if the judge cannot satisfy both the subjective and the objective standard. Again, the subjective and the objective standard. The subjective standard requires disqualification if the judge concludes that he or she cannot be impartial. The objective standard requires disqualification whenever the judge's impartiality might reasonably be questioned by a fully informed, disinterested observer, regardless of whether any of the specific provisions of paragraph summarized below apply. The standard focuses on public confidence in the integrity of the judicial progress. Let me start that over again. I feel like I was reading it wrong. Let's reset ourselves. The standard focuses on public confidence in the integrity of the judicial process before the court. That kind of goes to Geno's point moments ago, which is really emphasizing the fact that there's no public confidence, right? Even Geno said it here moments ago. You know, Britt Happens, again, ran a public poll. Allison said the appearance of public bias is enough. Geno, again, summarizes here, the appearance of impartiality is big enough. But how does it look to the public, the disinterested public? And I think that's what we're really fighting here in the Karen Reed case. You know, in Karen Reed's case, in Kelsey's case, is again a fight here to emphasize that we don't trust these judges. And I'll tell you this right now about Judge Beverly Cannoni. I'm convinced if she could have forced a third trial on Karen Reed, she would have went for it. I remain convinced of that to this day. And fortunately, the jury just got it to the point where she couldn't do it, because she sure as hell made sure that she could force a second trial at the end of the first trial. And as we saw, going to the SJC didn't help out, right? And I don't want to see Kelsey Fitzsimmons have to go through a trial similar to Karen Reed, where she's battling a judge that all of us do not believe can be impartial. And in addition to that, have to go in a situation where if this jury can't come to a verdict, that this judge will do anything she can to force an additional trial. Because none of us want to see Kelsey here in 2026 go to trial. Then all of it doesn't matter. And then here we are a year from now in 2027, and it's going to a second trial. Nobody wants to see that happen at all. And I think that's why this defense team is trying to get ahead of the curve on this. because there could be that risk. And they don't want to see this happen. And even worse, they don't want to see a situation that might risk, the worst case scenario for Kelsey either. So this is preventative measures. Scott McGinnis is in the house. He says Judge McCarthy-Neyman has clearly already proven her bias to the public that is aware of this case at all, in my opinion. Great point. Karen, how are you doing today? Hope you're doing well. Nice dog, by the way. I like that picture. All right, continuing. So making sure where I left off here. Yeah, this one we already got. Recusal is required where a judge has personal or economic interest that could be substantially affected by the outcome, has engaged in ex parte communications concerning a pending matter, has become personally embroiled with parties, counsel, or witnesses, or has taken action that viewed cumulatively. I'm going to say it again. Viewed cumulatively. I can't say it. What's going on, Mark? What's going on? Are you tired today? You can get this. Come on. Let's do it. Cumulative. I can't do it. I know this word. Cumulative. I can't say the word today. I don't know what's going on with me today. My goodness gracious. Cumulatively. There we go. Got it. Took like 5 tries. And I know the word. What's going on? Struggling today. I got the Super Bowl fatigue going on today. I think that's what. They're like, earlier today, Mazza was on his YouTube page and was mispronouncing words left and right. That's all right. Cumulatively. There we go. Boom. Got it. There we go. Undermine the appearance of impartial adjudication. Then it summarizes here. All of these recusal categories are present in this case. Procedural background relative to recusal. Ms. Fitzsimmons is before the Essex Superior Court sitting at Salem in a 1-count prosecution charging assault by means of a dangerous weapon, right? So that's it. That's what this is all about. 1-count prosecution charging assault by means of a dangerous weapon. All right. Judge McCarthy-Neyman presided on the case on August 14, 2025, for a bail petition in Essex Superior Court on August 28, 2025 for arraignment. September 9, 2025 for a bail hearing, and September 11, 2025, that day that will go down in infamy, with Kelsey basically getting sent back to jail, for an emergency motion for immediate relief from Scram. On both August 14, 2025 and on August 28, 2025, Judge McCarthy-Neyman was assigned to Salem Civil A Courtroom H, handling civil business in the Salem Superior Court. See Judicial Assignment Sheet for August 2025, attached as Exhibit 1. Nonetheless, she appeared and handled both the bail petition and the arraignment in the criminal session without any verbal or written explanation in court or on the docket. The assignment sheet for September 2025 attached as Exhibit 2. I'm wondering if, let's do this. Okay, let's take a step back. This is what we're going to do. We are going to go to those exhibits. Too many wings last night. Exactly, Dennis. Too many wings. Too many wings. All right. Let's do this. All right. Let's break for a moment here. So this says, let's repeat Exhibit 1. All right. Handling civil business in the Salem Superior Court. See Judicial Assignment Sheet for October 2025 attached as Exhibit 1. Let's go there. All right. Here we go. Exhibit 1. All right, this is Exhibit 1 that's being referenced. All right. Superior Court Administrative Office Judicial Assignments, August 4th, 2025 to August 29th, 2025. And then it's just going to summarize here, who the judges were, who the people were here assigned. Let's just kind of scan this real quick. Let's see what we got. I have not taken a look at this yet. Let's go up to bingo. All right, right there. Okay, so that just verifies Essex County Courtroom, Salem Civil A, Courtroom H, and it shows she was in fact assigned. And I think this should be it for Exhibit 1. Let's Let's take a look. This has all the, okay, that's Exhibit 2. All right, now back to this. All right. Nonetheless, she appeared and handled both the bail petition and the arraignment in the criminal session without any verbal or written explanation in the court or on the docket. The assignment sheet for September 2025, attached as Exhibit 2, also reflects her assignment to the same civil session. Let's go back there. All right, now we're at Exhibit 2. All right, hi, Ernie. Hope you're doing well. All right, this should show up. This section's highlighted here. Bingo. Essex County, again, right there. All right, see if there's any other information we need. And then it just shows regional administrative justices. Just list their name here again right there. Is this highlighting on screen? Perfect. Okay, good. All right, and then continuing. All right, that's Exhibit 3. All right, we'll go back. I just got a text from my sister. All right. Hope she's doing good. I haven't heard from her in a couple of days. So hope she's doing well. All right. My sister was a big, both my sisters were big Karen Reed supporters. And they didn't even know I was doing a show. They're like, one of my sisters was messaging me. She's like, I can't believe what they're doing to Karen Reed. I'm like, yeah, I know. I go, you know, I'm on YouTube about this. She's like, you are? She goes, that's why I would see you like in the background on the news. You know, occasionally. Sister just had her birthday recently. All right. There we go. All right, so that's Exhibit 1. This is Exhibit 2. This, again, summarizes her assignment in the same civil session. Nonetheless, she continued to leave the civil session and handle criminal business in Miss Fitzsimmons' case. So this is where this conflict of interest is coming in right here. I saw this summarized today on Facebook on the group page that the civil session and the criminal business, she continued to leave, right? You know, I'm just looking over this. Sorry, just give me one moment. Just glancing through this for a second. Right, so that just confirms again what her level, they're justifying her level of involvement. Criminal session, civil session, both on the list for both of them. That's them setting up, just trying to pick up this information too in my head as I'm reading this today. First time through it. Okay, so they're breaking it down. The criminal session, the civil session. Right, and then she handled both, I start to say. Okay, sorry, I just wanted to catch up mentally there a little bit. All right, still without explanation as to why she was doing that, essentially. Okay, without notice to the parties or the public, it appears she has specially assigned herself to this case, a one-count, simple 2 or 3-day trial where a conviction warrants only a sentencing guideline sentence of straight probation. The assignment seems inexplicable on the merits of the case and raises questions about the motive of the court so as to undermine the public's confidence in the ongoing adjudication. Okay. All right, very interesting here. Tell me what happened. Tell me what happened. I have not been following that case. But yeah, share as you wish. Thank you so much, MJ. I'll let her know. Thank you for that. Appreciate that. News on Enrique Garcia. Okay. Wow. That's interesting right there. Okay, so you already shared that information. Thank you. 4 people to be charged. All right. That must be 4 people at the facility. Yeah, share what you got on that. Let me know if those were people that were fellow recruits or if there were people in charge. I'd imagine at least 3 of those people are probably people that oversaw everything there. That's wild. Wow. That's very interesting news right there. Britt Happens says, by the way, Officer Noonan's real name is Patrick McCarthy-Neyman. I don't know if there's any family relation there, but wanted to make sure that was pointed out. I agree. And you know, so while there may be no fact that could be true, but that is something that would need to be vetted. You know what I mean? Like that information needs to be vetted. 4 people need to be charged. Seems he had a concussion the day before we had the sparring match. The people to be charged, yes, oversaw this one, puttered themselves, lied big time. That makes a lot of sense. That makes a lot of sense based on when we talked about that way back, and that was 2024. Yeah, that was September 2024, I think, when that happened. Wow. News conference was out of Attorney General's office. Okay, Worcester County. Okay, excellent. Well, good. That's great news. That's great news. All right, good. Good to see some progress there. All right, we'll continue forward here. The judge. I mean, honestly, like Bradle's office is arguing here, this judge has her hands in too many things. Civilly, criminally, it's just too much. And that's, again, my biggest concern is that, you've seen this happen in Karen Reed's case, even in Turtle Boy's case, where the defense motions for something like this and that just gets swept under the rug or ignored. That's my biggest concern here, but we'll see what happens. All right. Grounds for recusal. All right, so they're going to start to dig in here. But wait, it gets better. But wait, there's more. All right. I got a drink of water. Here we go. Prejudgment reflected in a dangerousness finding and other pretrial matters. These are the grounds for recusal. All right. In upholding prior dangerousness findings and herself finding Miss Fitzsimmons dangerous, good citing here, under 58A, the judge has been privy to and has adopted as fact evidence that would not come into a trial of the underlying charge. The court has made a subjective, personal finding that Miss Fitzsimmons is a dangerous person. I love that statement because that is a fact. That judge has, in fact, when that judge sent her back to jail, or sent her there in the first time, that judge essentially declared Kelsey Fitzsimmons is dangerous. I mean, why else would she send her to jail? Or even back to jail? She has repeatedly referenced her belief, that is correct, she has done that, necessarily by clear and convincing evidence that Miss Fitzsimmons is an ongoing and present danger to her assailant, Officer Noonan, who needs the protection of a dangerousness finding from her. That is absolutely true. The court has gone so far as to explicitly prevent any potentially favorable family court custody or visitation orders, right, by prohibiting Miss Fitzsimmons from seeing her infant child. Love it. Hone in on that because that's controversial. Yep. And even family, favorable family court custody. Exactly. That's insane. That's insane right there to me. That an RO was served and Kelsey has not even had a fair opportunity yet. That's still with the family court portion of this, this saga, I guess you could call it, still hinging on family court matters, and it's just insane to me. But she hasn't even had visitation of her child, which is absolutely outrageous to me. And everybody, and no one more outrageous than Kelsey Fitzsimmons herself, the mother of the child, that can't even see a child that she basically had in her womb for 9 months and gave birth to. My goodness. Oh, my goodness. This is a highly unusual finding, unprecedented, in undersigned counsel's experience. That's a big statement right there. Unprecedented. That a Superior Court judge would impair the family court in performing its own core function of determining custody and visitation in the first instance. Love it. Love that right there. They're basically saying, you know what, judge, you have overstepped your bounds and you are out of order. This court has gone far out of its lane. Love it. In an effort to keep Miss Fitzsimmons from her infant. I absolutely love that statement right there. Absolutely love that. That is great. And that's exactly what they've done. They're impeding the legal process. And they are violating Kelsey Fitzsimmons' rights. What? This is all because an RO was issued? Let's see what Mullen Law has to say. She's jumping in about the RO right now. There was already an RO issued by family court, and then this judge made no contact part of her bail conditions, complicating any move Kelsey might make to have parenting time. There you go. There you go right there. That's insane. Like she says, let's break this down again. Mullen Law says, then this judge made no contact part of her bail conditions, which only complicated any move Kelsey might make to have parenting. So Kelsey can't go to the family court, but she can, I mean, because that's going to come in a couple months. But it like she said, it's complicating stuff. This is absolutely outrageous. Oh my goodness. Thank you, Susie Q. She says, Mark, I ordered from Zabar's in 95 for my 95-year-old neighbor, and it took her back when she met her husband as they often went there. Her face just lit up when I brought over all the goodies I ordered for her. We love you. Susie Q, thank you so much. Love you too. Appreciate the super chat today. Thank you so much for that. I didn't see that. Didn't see that chat come through though. I must have missed it earlier in the show. But yeah, I must have missed that earlier. Thank you so much for that super chat. Yeah, I didn't see it in the chat come through though. It's like usually I catch those when I see them come through. But thank you, Susie Q. During the summer, the RO was filed in June. Yeah, supervised visits. I mean, come on. That's not even happening right now, which is absolutely insane. Then the family is having to go through, fighting hand and foot to try to get any kind of visitation at all. Yeah, it's weird. I didn't see. I swear that super chats from the other day, Jen. I had a super chat from that very person for that same amount, and they mentioned Zabar's on when I had Better on the other day. I swear that super chat's from Sunday. I don't know why it would be appearing. Why would it be appearing on this show though if it's a super chat from the other day? It doesn't make any sense. That's weird. I just saw it appear. I'm like, it says like starred, then there's a super chat there. I don't know why that was. Why it's appearing on a show from another show. It's weird. I've never seen that happen before on StreamYard. All right. You shouldn't be able to pull up a super chat from another show like that. And the system's allowing me to do it like that. That shouldn't, if that's a super chat from another show, that shouldn't even be there. Because when she says Mark, she's referring to Mark Betterow. So that super chat's from the other day. Why that's on the, yeah. I don't know what's going on. That's weird. Yeah. And then Ernie says, I haven't been getting live notifications yet. Yeah, that's weird. I've never seen that happen. Like, even again, I shouldn't have access in StreamYard to a chat from another show. All right, we'll continue here. Yeah, this case hurts my heart too. It's crazy. Yeah, it is so wrong. Again, because, you feel like, this is what we felt about Karen Reed. We feel like people's rights are being trampled on. Everybody should be able to go through the legal process through the normal process. There shouldn't be extra stuff, extra restrictions, and it's horrible. As much as I appreciate Attorney Tim Bradle, Martha Coakley, as much as I appreciate their fight for Kelsey, they shouldn't have to fight for these things, because and that's the issue I've seen in a lot of cases here in Massachusetts. Is it's like these attorneys have to fight for things. It's like you shouldn't have to, as an attorney, you shouldn't have to fight for the right of your client to breathe air without being charged taxes on them. You know what I mean? Like, this is not something that the attorneys, Coakley and Bradle, should have to fight for or argue for. And these judges should know it. But what bothers me is that when they do fight this, then sometimes they take it to the Supreme Court in Massachusetts. And then what happens? The Supreme Court says what? Well, we agree with the judge. How do you agree with the judge? There's different types of court systems, criminal, civil, whatever, whatever. It's insane. Family court matters should be done in family court. That's it. And to have one judge attempting to oversee everything, to be the all-knowing being or the all-overseeing being, is a little outrageous to me. And it's a shame that this defense team has to file these kinds of motions to basically argue Kelsey Fitzsimmons should be able to breathe without being taxed. And I'm just using that as an example because we don't get taxed for air yet in this country. Not yet, anyways. There's still 30 more years. All right. I think I read this whole paragraph, right? Yep. I'll just read this one more time. This court has gone far out of its lane in an effort to keep Kelsey Fitzsimmons from her infant. The court's findings in these areas amount to an expression of her opinion on the character and guilt of the defendant. Again, that's not for the judge to decide. That's for the jury to decide. And Andrea Burkhardt is aware. We found out on Twitter earlier today. Andrea Burkhardt had responded to a few posts, and she's starting to kind of become aware to this, which is great news. We need a lot of the big name attorneys to cover this. Brother Counsel, one of them, of course, but Melanie Little, one of them as well. But just the more attorneys that have YouTube shows that can start covering this would be great. I want to see everybody cover this. I know, that's just the most important thing. And again, I understand like my limitation. There's only so much I can talk about, so much I know, so much I can hype this thing up. There's only so much we can all do. When you get those big name attorneys up there and they're talking about this, it just amplifies this whole case. And that's what we need. We need to have as many big name people. And I don't mean just big names, but everybody, really, everybody. Everybody should, regardless of whether you're have 100,000 followers on YouTube or 1,000. We just need to amplify this story as much as possible to raise awareness of what's going on. Because like I said earlier in the show, I'll say it again. I believe this story should just be just as big as Karen Reed. And in my opinion, we're pushing it the best we can. And we're getting there. Look, we've raised $70,000 collectively, all of us, so far for Kelsey. And we're going to continue to push that thing. We want to get it over 100,000. We're going to do another fundraiser on Sunday, do the best we can, and keep pushing this. But I'd love to see Andrea Burkhardt cover this. I know she was talking about it today on Twitter. That would be huge because, again, more eyes need to be on this. Kelsey needs that as much support as possible, just to help her, back her up. And because, again, people like Kelsey, Karen shouldn't have to go through these types of things. We're going to see what ends up happening, but we're going to do as much as we can. That's for sure. And all of us matter in helping Kelsey. Every single person that's here, that's pushing the story out. We're all doing our part, and we'll continue to grow this story the best we can. And that's all we can hope for. But again, this is a chaotic story and very, very tragic story as well. Yeah. And Mullen Law says, look for fundraiser on Friday for Valentine's Day. Nice. MJ throwing up the purple hearts. Yeah, I'll try to reach out to Andrea Burkhardt a little bit here as well. Britt Happen says, I'd love an opportunity to speak with Andrea about some of her views about how the SJC has ruled on Kelsey's case in particular. I agree. Massachusetts seems to avoid overturning circuit courts by default. I agree. They always seem to rule in favor of the initial ruling of the judge, which bothers me quite a bit. Water time. All right, drinking from the collection cup, the Tail Light collection cup. All right. I'm just going to start from the beginning here. The court's findings in these areas amount to an expression of her opinion on the character and guilt of the defendant. There are several relevant legal guideposts for the proposition that a judge who makes adverse pretrial findings on a case should avoid sitting as the trial judge. Let's reread that whole thing over again to really bring it home. There are several relevant legal guideposts for the proposition that a judge who makes adverse pretrial findings on a case should avoid sitting as the pretrial judge. This right here, to me, is the bread and butter of their entire argument to have her recuse herself right there. That's, without getting into all the details, That's that's a big point right there. Congratulations, Seattle. You guys finally avenged Super Bowl 49. But we know when you lose the Super Bowl, the best way to avenge it is just to get back and win it. And I hope the Patriots can do the same here in the next couple of years. It was a tough loss, but, again, Seattle had a great team this year. They won. Didn't expect the game to go that way for the Patriots, but it did. But to all the Seattle fans, congratulations. Again, Patriots, looking forward to their future here in the next couple of years to see what they can do. And, there's been a lot of Super Bowls the Patriots have lost with younger rosters, and they come back. And I'm sure the Patriots are going to rise like a phoenix here in the next couple of years, and we'll be having our fireworks again soon. Go Patriots. We'll be back. Drake May said it. We'll be back. Thank you so much, Nancy. I appreciate that. You're doing a great job fighting for Kelsey, too. Thank you. Yeah, I'm a good sport about it. We've won, we've lost, but we're going to continue to fight for more Super Bowls. It's just like fighting for Kelsey, right? No matter what happens, you stand up and you continue to fight. If your favorite sports team loses, you stand up and fight. You don't give up. You don't quit. You don't cry about losing a Super Bowl. You get back up, you get a team together, and you get out there and you win. That's my attitude about sports. That's my attitude about Kelsey's fight and Karen's fight, is we get out there, to use sports as an example. As a former athlete, as really an active athlete, but I'm not a competitive athlete anymore. That's what I did. We'd lose a game. All right, what are we going to do to win the next game? We had a bad ending to our season. What do we do to win the next season, right? That's what you do. And just like with Kelsey or Karen, when things don't go your way, what can you do to make adjustments, move forward, and get victory? And that's how it has to be all the time. The Seahawks, look what they did. Their franchise was down for a lot of years. They came back. The Patriots went down yesterday. Guess what? They have an opportunity to come back. Kelsey's been going through a fight. She has an opportunity to come back and win this thing. Karen had a long fight. She overcame it. And that's what this is all about, is we have to have a championship mentality at all times. We don't cry about losses. We don't give up. We fight because we have no quit. And that's the attitude we all always have to constantly have. And that's what these defense attorneys are doing too, is even though they've lost in the Supreme Court, they're still going to battle for this judge to recuse herself. And that's exactly the mentality you have to have. Constantly finding ways to win, constantly trying to find a path to victory. And that's what's great about these defense attorneys. Let's do what we can. Let's give ourselves the best opportunity to win this trial. And if we don't feel that this judge is doing a good enough job or is not in any way favorable and it lacks being impartial, let's try to get her to recuse herself. Let's file some motions. And that's what winning's all about. That's what victory is all about. It's constantly having a forward progressing attitude, regardless of a set of circumstances, and constantly finding a path forward. That's my mentality. That is my mentality, ladies and gentlemen. All right. This is about the guideposts. Yep, we have that read. Okay, perfect. All right. In the Parentus Supra, 32 Mass. Let's skip all that because I hate to read all that stuff. The trials court's finding that the defendant was untruthful in the past, right? The trial court's finding that the defendant was untruthful in the past, and its failure to recuse at the jury trial was found to be an abuse of discretion by the appeals court. So they're summarizing, something else that happened here, right? The appeals court, in another case, the appeals court found his actions constituted error because if, after applying the two-part test of SJC rule, a judge finds that he should disqualify himself under either part, he must allow the motion. Possible consequences of his recusal on the commencement of the trial are immaterial. Further, a judge cannot partially recuse himself. Once a judge concludes that there are grounds for recusal, he must completely disassociate himself from participating in the case. Ordering a jury trial, as the judge did here, does not substitute for allowance of a recusal motion, even if he is not the fact finder. A judge presiding at a jury trial performs important functions. A lot of citing here. Then it says here, the judge's role at any trial is to be the directing and controlling mind at the trial and not a mere functionary to preserve order and lend ceremonial dignity to the proceedings. Obviously, during the course of a jury trial, A judge, by exercising his discretion on various matters, makes important decisions which may affect the verdicts returned by the jury. That's what I was kind of thinking about a few minutes ago. I'm going to read this again. A judge, by exercising his discretion on various matters, which goes back to this judge already having an idea on Kelsey being dangerous. That's exactly what they're citing here, is that this judge basically already has a preconformed notion of Kelsey being dangerous, right? And it says a judge, by exercising his discretion on various matters, makes important decisions which may affect the verdicts returned by the jury. Basically saying, look, this judge is not legitimate. This judge cannot be trusted. And if this judge is going to preside over this case, then this judge cannot be impartial, because this judge has already determined that Kelsey Fitzsimmons is dangerous, right? And that could affect the jury verdict. And that means that this judge should recuse herself. End of story. Drink of water, ladies and gentlemen. You got it, Allison. Absolutely. You get knocked down, get back up every time. Thanks, Mazza. We need to hear this today. Exactly. For many reasons. Exactly. It's always a push forward in life. You know, you don't quit. You don't give up. You know, if you want to cry for a little bit, you want to lick your wounds for a little bit, you do that in life. But you get back up. You get back in there. You continue to push forward. And that's it. Always find a path forward to victory. Always find a path forward to success in everything you do in life. And you will succeed. Success might not come right away. It might take a while, but you continue to push forward and you will find success. And that's what Kelsey's defense team's doing. That's what Karen's team did. Karen Reed's defense team got through all the obstacles, pushed through. After 2 trials, they got what they wanted. Now it's civil court time. We'll get there, ladies and gentlemen. We will get there. Absolutely. All right. Let me see where I left off here. Okay. I'll just reread some parts here. Obviously, during the course of a jury trial, a judge, by exercising his discretion on various matters, makes important decisions which may affect the verdicts returned by the jury. Therefore, a courtroom has no place for a judge whose impartiality in a matter may be reasonably questioned, right? Reasonably questioned, may be reasonably questioned. And I feel that this judge, like Bradel and Coakley are saying here in this motion, that this judge has given grounds for why she may be reasonably questioned. You've declared her as dangerous. You sent her back to jail. Even if he is not the fact finder, we vacate the judgments and remand the case to the housing court for a new trial. Love the argument here. Love the motion here. Let me catch up on some comments here. Britt Happen says, yes, the judge is like a referee. Jeno says, and has acted on it. Impartial is an understatement. I agree. Scott McGinnis says, the SJC hates to throw shade on lower court judges. They are all governor appointed, all the same team. That's a great argument. That's also a great justification, Scott, as to why those results are coming here. Jeno says, I mean, comparing to Cannoni, she based her decision on how social media portrayed her. This judge took an extra step by actually seeking out info before the hearing and filing a complaint accusing. All right, continuing. All right. In parentu, the court's pretrial findings regarding untruthfulness of a party were dispositive for recusal from the trial, and selection of a jury was not a remedy. Yeah. Right. That's basically, I think, where she said Kelsey was a liar, right? They thought Kelsey was lying. Right. The court's pretrial findings regarding untruthfulness of a party were dispositive for recusal from the trial, and selection of a jury was not a remedy. The foregoing findings against Ms. Simmons are equally dispositive for recusal and are further supported by the present court's comments against counsel. Here in its order dated September 16, 2025, document number 19, this court has alleged that defense counsel did not transparently provide information resulting. One second. This court has alleged the defense counsel did not. Right. This court has alleged that defense counsel did not transparently provide information resulting in a manipulation of the court relative to the defendant's physical condition. Yeah. Interesting. Okay. Right. That was when they had the argument. Right, about her health. Resulting in a manipulation of the court role. Yes, I remember this now. Right. So they're basically arguing. It's basically as if they're trying to discredit the defense team, basically, the court. Court alleged that defense counsel did not. Right. That's when I said, oh, you didn't provide the actual things you needed to provide. That's when the judge, is being ridiculous, which she always is. That was when I think the medical letter, there was the medical letter or something like that or whatever. And they said they hadn't provided sufficient information to the court to prove that Kelsey had a certain physical condition. I believe that's what that was about, if I'm recalling that correctly. The defense denies the claim and has not had any opportunity to address it. Very nice comment there. I like that. In any event, the court's personal conclusion in this regard gives the appearance as well as the actuality of partiality on the part of the court requiring recusal, as was the case in parentu. Any other result would be an abuse of discretion. Okay. Right. She has been accusing the defense of trying to manipulate the court. Exactly. That's how I'm interpreting that. All right. Comment 3 to Rule 2.6 of the Code of Judicial Conduct also addresses similar circumstances where a judge is exposed to settlement or plea discussions and decisions, and states judges must be mindful of the effect settlement or plea discussions can have not only on their objectivity and impartiality, but also on the appearance of their objectivity and impartiality. Despite a judge's best efforts, there may be instances when information obtained during such discussions could influence a judge's decision-making during trial, and in such instances, the judge should consider whether disqualification may be appropriate. I honestly think this judge is not going to recuse herself, though. That's my honest opinion. I really don't think she's going to recuse. I don't know what the heck. I don't know. I just see this judge refusing to recuse. Adverse findings in a 58A context involve the same negative connotations as partiality against defense counsel, plea, or settlement discussions, and should be included in the same calculus for a sitting judge on both the subjective and objective prongs as to whether an appearance of bias exists. Well, I guess that's it. If she's already declared Kelsey to be dangerous, then that's essentially bias, because that judge has formed an opinion on the defendant. She has acted on that opinion of the defendant by sending her to jail. And then sent her back to jail just because they wanted to change up. They had an emergency hearing about her condition. The judge ignored that. It's crazy that, it's crazy to me that these defense attorneys have to literally go to war with a judge before a trial. And then if the judge, for any reason, is still on the trial, then then you have to deal with this judge who already knows that basically you tried to throw him off. So at this point, isn't that bias as well? Think about it. If you say, hey, if you're playing for a sports team and you say, coach, I don't like you and I think you shouldn't be my coach. And the coach says, well, I'm not going to quit as coach. I'm your coach. Then you still have to play for that coach for the entire season. Is that coach not going to give you less minutes or bench you for the entire game? It's going to be a tough situation to play on that team because you've already had it out with your coach. Well, it's the same thing in court. If they say, hey, we're trying to get you thrown off or to have you recuse yourself, and now she doesn't recuse herself, wouldn't that judge now be biased against the defense because they tried to get her to recuse herself? You see what I'm saying? Like, that's my argument here, Now wouldn't that judge inherently be biased as a result of the defense trying to get her to recuse herself? So it's, I don't know. Just some thoughts I have there. Just some thoughts. Similarly, the reporter's notes to Mass R. Crim P30 relating to post-conviction relief address whether the trial judge who presided over a defendant's conviction should continue over the matter. Okay, great point there. A trial judge who presided over a defendant's conviction should continue on the matter. Okay, referring to that particular case. Then that brings it back to Judge Kathleen McCarthy-Neyman sending Kelsey to jail. Well, in the first instance, the case should start with the trial judge. The trial judge may bring to the hearing a prejudice that another judge would not have. That's what I mean. Recusal of the trial judge should thus be liberally exercised, particularly where it is requested by the moving party. All right, there's a citing here. Reporters notes to blah, blah, blah. Thus, the rule recognizes that prior findings and proceedings contain objectivity and that recusal should be liberally exercised, especially where the moving party requests it. One moment, I'm going to digest this for a second. The rule recognizes that prior findings and proceedings can taint objectivity and that recusal should be liberally exercised, especially where the moving party requests it. The court's prior findings relative to the character and fitness of the defendant as a mother, right there, as well as the court's criticism of defense counsel, conclusively demonstrate that the court's objectivity is tainted, warranting recusal. That is extremely well said right there. Mullen Law says she is acting like an attorney for the Commonwealth, not a judge. Well said. Well said. I think that's extremely well said here. That means recusal should be overdone, if anything. Yeah. Yeah. I mean, this is just, at this point, she filed an actual complaint accusing probation of colluding with defense. She had already predetermined the outcome. Scott says the judge was upset with probation in real time the day of the hearing. She tossed Kelsey in jail. She was upset that probation's account didn't fit the judge's help. Kelsey never violated. Yep, but she also went and spoke to probation the day before the hearing. This is a disaster. This judge is a total disaster. Total disaster. Total disaster. Finally, the court's demeanor and actions at the September. Yeah, here we go. They're coming. They're going in for it. Right here it comes. They're citing this, aren't they? And I don't blame them. Finally, the court's demeanor and actions at the September 11, 2025 pretrial hearing also provide ample grounds for recusal. Rule 2. Oh, I love how they're going after her for this. This is beautiful. Brado. Love it. The court's demeanor and actions at the September 11, 2025 pretrial hearing also provide ample grounds for recusal. Rule 2.3 of the Code of Judicial Conduct, Comment 1 provides, a judge who manifests bias or prejudice or engages in harassment in a proceeding impairs the fairness of the proceeding and brings the judiciary into a disrepute. A judge must avoid words or conduct that may reasonably be perceived as manifesting bias or prejudice or engaging in harassment. The recording of the hearing, and this is the one that gets me fired up, the recording of the hearing accurately preserves and demonstrates the court's prejudiced demeanor and actions and should be grounds enough for the court to step off the case on appearance grounds. the defense would admit a copy of the recording at the recusal hearing. Beautiful. Beautiful, beautiful, beautiful. Love it. Love it. Love it. Love it. Love it. Love it. All right, good. The Massachusetts legislature also has recognized through passage of this section that a judge who considers prior adverse findings against the defendant through plea negotiations should not sit on a trial for that same litigant. An additional chapter provides that in the district and Boston municipal courts, at the option of the defendant, the trial may be before a judge who has not rejected an agreed recommendation or dispositional request made by the defendant pursuant to the provisions of Section 18, Chapter 278. Review in such cases may be had directly by the appeals court, by appeal report, or otherwise in the same manner provided for trials of criminal cases in the Superior Court. The legislator has provided a blanket veto to the defense where such information has been tendered pre-trial. In the circumstances at bar, a judge who has rejected the defense request for release and found her dangerous and unfit, sitting in pretrial judgment of a defendant, should not handle the trial of this matter. Judge McCarthy-Neyman should recuse herself from the trial and any further substantive pretrial proceedings. I mean, this is it right here. Let's reread this. In the circumstances at bar, a judge who has rejected the defense request for a release and found her dangerous and unfit, sitting in a pretrial judgment of a defendant, should not handle the trial of this matter. This is all well said. This is all beautifully said here. Beverly was better at making her bias fit within bounds. This judge is worse. I agree. The recording accurately recorded judge's biatch self. Yeah, pretty accurate. Diane says a no-quit attitude can move mountains and bring you closer to the goal line. Absolutely. All right. Findings of dangerousness and parental unfitness when viewed in conjunction with ex parte communications, personal accusations against counsel, that's fact, and the judge's own extrajudicial interests all combine to demonstrate that this court has prejudged critical issues central to the case. Continued participation might cause a reasonable observer to doubt the judge's ability to approach subsequent proceedings impartially. I'm still concerned this judge will not recuse herself. Personal and economic interest creating an appearance of bias, Section 2 here. Basic internet research shows that Judge McCarthy has resided, here it comes, I heard about this today. So, for all you folks that don't trust people from Canton, here comes your North Andover conspiracy. I'm going to get a nice little drink of water before I read this section because here it comes. Basic internet research shows that Judge McCarthy has resided in the town of North Andover for approximately 25 years. Exactly, Jen. Exactly. 25-year resident of North Andover. Let that sink in for a second. Public real estate records indicate that she listed a homeowner. She is a listed homeowner in the town. She was the founder and principal of the law offices of Kathleen M. McCarthy, a criminal defense firm in North Andover. Okay, that firm is located in North Andover and is listed in Massachusetts Lawyer Weekly from April 29th, 2020, as a former sole practitioner in North Andover from 1997 to 2028. In adjudicating the alleged dangerousness of Miss Fitzsimmons, a fellow North Andover resident, in a North Andover incident, the court, this is beautiful. This is fantastic. They've done such a fantastic job with this motion. Oh my goodness, this is great. This is fantastic to read. All right, I'll read this again. A fellow North Andover resident in a North Andover incident, the court inevitably has to consider the safety of herself, her own family, and former colleagues that work or live in the town. As a taxpaying resident, the judge has a vested interest in the financial. Oh my God! No, they are. Wow. As a taxpaying resident, the judge has a vested interest in the financial security of the town and its reputation in the Commonwealth. Wow. Wow. On the unique facts of this case, one North Andover Police Department officer, Patrick McCarthy-Neyman, again, McCarthy, which was pointed out by, I think, Jeno in our chat earlier, Patrick McCarthy-Neyman shot and almost killed another North Andover Police Department. Let me start from the beginning. One second. On the unique facts of this case, one North Andover Police Department officer, Patrick McCarthy-Neyman, shot and almost killed another North Andover police officer, defendant Kelsey Fitzsimmons. The police immediately adopted and believed the story of the shooter officer and never sought to interview Miss Fitzsimmons, who fought for her life for 53 days in Massachusetts General Hospital. The case involves only these two officers as witnesses with no body camera video. Again, no body camera video. The defendant has potential civil claims arising from the conduct of governmental actors in this case, claims that could foreseeably expose North Andover to substantial financial liability. Municipal tort liability directly implicates municipal finances and taxation, and as a resident property owner, the judge has economic interest that could be affected by the outcome of this trial. Such an interest is disqualifying where it might cause a reasonable observer to question impartiality. Wow. Wow. That was huge. That was huge. Boom. Boom. Wow. Never sought to interview Miss Fitzsimmons. So they just basically said, hey, let's not interview all the witnesses. Let's just come out with their own conclusion. We believe what our officer said. Yeah. What happens, what he said. Trust me, bro. Unbelievable. Yeah. This is an interesting angle for sure. Never thought of this angle, but it's brilliant. This is brilliant. This is absolutely brilliant. And again, I still don't think this judge is going to recuse herself. I'm just getting that stubborn, whatever, I do what I want vibe from her. That's a South Park quote. Whatever, I do what I want. Wow. They went all out on this, huh? This is great. All right, next up. Another Essex Superior Court judge, Kristen Buxton, recused herself in similar circumstances as a taxpayer in the town of Ipswich. I heard the clam box in Ipswich is fantastic, by the way. Yeah, her sources trust me, bro. Excuse me, the police officer sources trust me, bro. Yeah, she, it's like the whole thing in Star Wars, who shot first? Trust me, bro. It's ridiculous. All right. Another Essex Superior Court judge, Kristen Buxton, recused herself in similar circumstances as a taxpayer in the town of Ipswich in another matter. Culpethorne was a taxpayer suit under boom, and Judge Buxton, an Ipswich taxpayer, recused herself, noting an appearance of impropriety. Struggling with that word today. Struggling with some words today. Impropriety. There we go. Seeking to ensure the greatest possible public confidence in the court's independence and impartiality, she recused herself due to her ties with the town. She stated, the Code of Judicial Conduct, Supreme Judicial Court Rule 309B, sets forth that judges should avoid both impropriety and the appearance of impropriety. This is to ensure the greatest possible public confidence in their independence and impartiality. As I am a property owner in the town, and despite no actual conflict, there may be an appearance of conflict. See order dated September 29th, 2023, document 14 attached as Exhibit 3. Boom. Let's go to it. All right, so this is Exhibit 3. All right, rolling here. Let Mazza cook. Yeah, I agree. Let them cook. All right, Exhibit 3. This is it right here. So this is great. They've got all this stuff. They've done their homework. They're citing their sources. They're providing exhibits as backup. And this is what that judge wrote, Kristen Buxton. This is just backing up exactly what they wrote in their motion, where she recuses herself. Very good. Good stuff. It's good to dig for this stuff, cite this stuff, put it in there. They've done this defense team has done a fantastic job. The appearance of impartiality is comprised when a judge sits in judgment over a case where the outcome may affect her own municipality's financial exposure. Judge McCarthy-Neyman should mirror Judge Buxton's decision in Copethorne and withdraw to avoid the appearance of a lack of impartiality. They've really sat back here. This defense team has really sat back here and said, let's look into this judge. Let's do our homework on this judge. Let's find out what town she lives in. Is she a tax-paying resident? Is this a North Andover matter? That much we already know. It involves North Andover police. It involves a North Andover police officer. Let's find out about the judge. Oh, the judge works in North Andover. Has any other judge ever presided over a case? Over a case that has a situation that involves that judge's town? And would that judge have a vested interest in how that town's affected by any lawsuits? They went back, they did their homework, they found the Judge Kristen Buxton recusing herself, and that's all in here. This is great. This is great research. This is great homework by Bradel and the defense team, and this motion's fantastic. Again, I'm just concerned this judge won't recuse herself because I feel like she's going to be stubborn like Judge Beverly Cannoni, who Scott McGinnis is referencing right now. When Judge Beverly Cannoni was moneyed, motion to recuse herself in Karen Reed pretrial 1, Bev went to her chambers for 15 minutes after what I believe calling DA Meatball came back and said, nope, I own this. I agree with your theory 100%. And I remember that. Some kind of call was made there for sure. 100%. Continuing. Thank you, Scott. I read that. All right, continuing. Part 3 here. Ex parte communications with probation concerning a pending matter. Undersigned counsel has recently been informed that Judge McCarthy-Neyman had an ex parte and an undisclosed conversation with Assistant Chief Probation Officer, here it comes, Jeff January on September 10, 2025. This conversation occurred, I think, Jenno, this is what you were referencing earlier. This conversation occurred the day before the court sua sponte revoked Ms. Fitzsimmons' bail and returned her to custody, cut off her defense counsel, invited objections from the Commonwealth, walked off the bench when counsel was addressing the court, vilified ACPO January in open court. Yep. And was visibly shaking and angry. Counsel was informed by ACPO January and his attorney that Judge McCarthy-Neyman came to his office unannounced the day prior to the hearing. She sought to investigate the status of Ms. Fitzsimmons' compliance with probation terms. This is wild. This is wildly improper and unethical. Yeah, this is insane. She sought to investigate the status of Ms. Fitzsimmons' compliance with probation terms, and when it was informed by ACPO January that there was no violation, and again, he stood up for Kelsey in that term, right? ACPO January recalls that he discussed the fact that he had email communications with undersigned counsel. I mean, at this point, she should not only recuse herself, she should be disbarred at this point or removed as a judge. This woman, this is unbelievable. She should step down from the bench in disgrace. January recalls that he discussed the fact that he had an email communications with undersigned counsel, which appeared to upset Judge. One second, sorry. Mentally digesting. Okay. He recalled that he had discussed the fact that he had email communications with undersigned counsel, which appeared to upset the judge. When January mentioned that his emails favorable to the defense were likely attached to the motion filed for relief, the judge abruptly left ACPO's January's office. There was no legal justification for the court visiting his office and conducting its own investigation outside the presence of defense counsel off the record and without subsequent disclosure to the defense. This woman should be removed as a judge entirely. Thank you, Courtney. I appreciate it. This is insane. Methinks the probation department does not like the judge. This is wild. This is insane. This is absolutely insane. This is crazy. I mean, I've never heard of a judge doing something like this. This is absolutely madness. All things should be conducted in a proper manner. She's having conversations with this guy on the side. This is madness. This isn't even a matter at this point. This is not. I mean, to me, this motion's about her recusing herself, but I think this judge needs to step down permanently. To me, this is unbecoming behavior of a judge. And she's not a prosecutor trying to interview witnesses. Maybe I'm wrong. Has any judge ever done something like this before? And that's okay. I don't know. Maybe I'll have to look into it. Just wow, indeed. Ex parte communications are no small matter, especially if they were not disclosed to the non-participating party. Well, that's what I mean. Yeah, exactly. This is insane. 100, proof of improper conduct. Mullen Law is an attorney, just so you guys know. Wow. This is why I don't think there will be an evidentiary hearing. I think she will step down to prevent it. Yeah. This is great job by Bradle and the team. Great job. You guys think that they probably talked to January on the side, the defense team did, to get this information? There's no legal justification for the court visiting his office and conducting its own investigation outside the presence of defense counsel off the record and without subsequent disclosure to the defense. That is just insane. This is crazy. I'm trying not to F-bomb right now. This is going on Twitter. Hold on. This is going on Twitter right now. Give me a second. This is crazy. This is insanity. I've never heard of something like this in my life. And Mullen Law, I know you're watching right now. Have you ever heard of something like this ever happening? This is going on Twitter right now. I'm posting this. Grabbing some screenshots as we speak. Holy mackerel. I'm posting this on Twitter right now. Wow. That's crazy. Wow. I just cannot get over that. Never ever. This is absurd. It's absurd. Yeah. This is wild. This is crazy. This far goes beyond Norfolk County, folks. I know we've all been Karen Reed supporters for a long, long time, but my goodness, this goes to show you there's a lot more going on in this state. My goodness. My goodness gracious. Wow. Thank you guys for bearing with me for a second there. These ex parte communications concern matters bearing directly on the defendant's liberty, which was at stake, unbeknownst to defendant the very next day. Such conduct directly violates Rule 2.9, prohibiting ex parte communications where a judge receives information outside the adversarial process and then presides over related proceedings. The appearance of impartial adjudication is irretrievably lost. Add this to the post, too. Allow me to do it. I'll just reply with it. This is crazy. This is just absolutely outrageous. What the hell? I don't understand why the judge would do this. I'm not talking about like from a corruption standpoint or whatever. I just mean like, why would you ever do something like this? Section 4, personal embroilment with probation and defense counsel. Undersigned counsel was recently informed that following the September 11, 2025 hearing on the emergency motion for relief. I'm sorry, I have another thought. Let me go back. To me, this proves conspiracy to throw Kelsey Fitzsimmons back in jail. Am I wrong about that? Am I wrong that if this had taken place the day before she was sent back? What was the date on that again? Right. September 10th, the day before. The conversation occurred the day before court. Then she went back. And at that point, that was just an emergency hearing to basically cite the fact. This is insane. My brain is exploding right now. Like, this is just wild. This is just insane. So you mean to tell me this took place? So when Bradel was going to call an emergency hearing to say, hey, guess what? Kelsey can't handle this test. We want to have her simply do other tests. You mean to tell me that this conversation took place the day before? This is unbelievable. This conversation occurred the day before she revoked the bail and returned her to custody. Right. Cut off the fence and then just see, that makes it seem like this was all pre-orchestrated. This just seems to me like the way I'm reading this, it basically makes it seem like this judge was trying to do her homework to get any angle on Bradel and Kelsey Fitzsimmons to ensure that Kelsey Fitzsimmons would be thrown back in jail, which tells me that this is an absolute conspiracy. Am I wrong? This seems like, to me, this is crazy. It's like we always say, it's always bigger and there's always more going on than we realize. This completely justifies that right now. Then she walks off the bench. You know, and I wonder if there's other people pushing these judges' buttons. You know, Scott McGinnis just said it himself earlier. You know, when Bev was trying, push to recuse herself, she disappeared for 15 minutes, allegedly made a phone call, Yeah, Liz, I know. Great question. Yep. We don't all have tinfoil hats on. Exactly. Let me get mine. Hold on. Personal embroilment. Let's go to section 4. Personal embroilment with probation and defense counsel. Undersigned counsel was recently informed that following the September 11, 2025 hearing on the emergency motion for relief, McCarthy-Neyman filed the complaint against. Am I reading this right? Counsel was recently informed that following the September 11th hearing on the emergency motion for relief, the judge filed a complaint against January arising from this case. This is despite her unclean hands engaging in ex parte conversations in the probation office. Upon information from ACPO January's attorney, the complaint filed by Judge McCarthy-Neyman included accusations of defense counsel colluding with probation. Defense counsel colluding with probation. Well, in turn, the defense is now able to clearly state that the judge was attempting to conclude with probation. As a result, defense team members are now supporting witnesses for ACPO January against the judge in this complaint that directly stems from this very case. As a result, the complaint itself is strong evidence of the court's actual bias against undersigned counsel and or Ms. Fitzsimmons. This is crazy. This is, I mean, this defense team is, I'm sorry, I didn't share this large, did I? Sorry, guys. Wow, this defense team's coming out swinging. No wonder why. I got tipped off about this yesterday morning, and I was sworn to silence. It was not by the defense team, just so you guys know. But I got tipped off that this motion to recuse was coming. And this is insane. Mullen Law says she's not only unethical, she's not too bright. Filing the complaint against the PO is just dumb. Right, exactly. Exactly. As the result, the complaint itself is strong evidence of the court's actual bias against undersigned counsel and or Ms. Fitzsimmons. At a hearing on the ACPO January probation matter, undersigned counsel would attack this court's position and credibility and assert that the court's complaint is false, baseless, and merely At the hearing on the ACP probation matter, undersigned counsel would attack this court's position and credibility and assert that the court's complaint is false, baseless, and merely dissatisfaction with an undersigned viewpoint from probation. Right. On its face, I don't see what probation and defense counsel would even collude about. That's a great point. What would they collude about? Collude about at all? Rhonda, I hope you're doing well today, Rhonda. Good to see you. Can they get any more scraped on because of the judges? Yeah. In fact, counsel would also assert, make sure I'm zoomed in right. In fact, counsel would also assert that January at all times acted fairly, truthfully, and professionally. Now, I vouch for that as well as a viewer of when January was there. I thought he did a great job. I thought he was very accurate, honest, forthcoming with Kelsey's state of health at that particular point, and unreal. Mr. January did everything that he could to accommodate Ms. Fitzsimmons' disability, unlike the court itself. Right, because the court was just like, they didn't want to hear it. Nope, she's going back to jail. Send her out of here. Walks off the bench. I'm going to repeat this. Mr. January did everything that he could to accommodate Ms. Fitzsimmons' disability, unlike the court itself, and deserves praise and the full support of the probation department rather than an assault on his reputation. Further, the court's complaint is proof that the court's foray into ex parte investigation before the hearing simply didn't produce the desired information and resulted in the court vilifying January the next day at the September 11th hearing without any cause whatsoever. Yeah, I agree. You know, they're saying the defense colluded when this judge was talking to him the day before. I'm going to repeat this again because I think it's worthwhile reading again. Sometimes I like to repeat stuff because I like to grind things in our heads. Further, the court's complaint is proof that the court's foray into ex parte investigation before the hearing simply didn't produce the desired information and resulted in the court vilifying January the next day at the September 11th hearing without any cause whatsoever. In addition, and perhaps most compelling for recusal, the fact that the court did not disclose this complaint to counsel for Ms. Fitzsimmons is strong evidence of the judge's bias and lack of impartiality. That's exactly right. Why would this not be disclosed? Why would defense counsel not be informed? Why would they not be advised that this communication took place? Why would this be held in secret? Why should the defense be accused of colluding with the probation officer when, in fact, It was the judge the day before September 11th, 2025, that was speaking with the probation officer. Then she just turns into this Disney villain right before our eyes in the courtroom. This is unbelievable. A judge who has entered and she still completed them. Exactly, Scott. She still completed those tests. And then basically the judge ordered off with their heads like it was Alice in Wonderland. This is crazy. All right. A judge who has entered the fray, particularly by leveling accusations against counsel of record and court employees who provide good faith assistance to defense counsel, cannot thereafter preside without creating an appearance of partiality. The court must recuse. I agree, 100,000%. I mean, like I said, this is not only a matter at this point of recusal. This is a matter of whether or not this judge should even be presiding over any cases in the state of Massachusetts at all. I mean, let's be honest. I mean, this to me, they're motioning for recusal, but I think this what they're stating here, it makes an argument even bigger. I mean, at the very least, if she's not presiding over this case, that's great. You're not wrong, Mary. I mean, honestly, you're not wrong. Jeno says, and then to not disclose to the defense that she was quite obviously trying to do it secretly. That's right. All things should be brought to the attention of all parties. And if they all, you see, that's the thing. If everything is brought to the attention of all parties, then that is fair, right? That is an objective way of conducting things. But if it's not at all, things are being done in the shadows. KY Maverick says CJC file complaint should be filed. Yeah, do it. I think that, and I'll say this, KY, to go with that, to that point. My guess is they're probably working on that, if I had to guess. If they're, because this cannot go to trial with this judge. That is, after reading this now, I was never a fan of this judge, let's be honest. Back in September, I was not a fan of what she did. Now I'm reading this stuff, and it's like, I don't think this, I cannot imagine any defense attorney in the state that gets word of this is ever going to want to defend any client with this judge ever again when they're reading this. That's the impression I'm getting. Is I'd like to know if any defense attorney would ever want to have any defense appear before a court to defend somebody in trial under this judge if this judge is doing this. Probation would be violating people every day for late scram tests. It's ludicrous. Sometimes probationers are a bit late. Sometimes the tech doesn't work right. Poor connections, a whole plethora. KY Maverick says, I have already filed 2 CJC complaints, never open an investigation. Thank you, KY, for all you do, man. Appreciate it. This goes before the SJC. I hope they get it right this time. I know that's my concern too, is every time anybody tries to go to the SJC, they just defer back to the judge's initial ruling and understanding. Goodness gracious. Let's reread this part. A judge who has entered the fray, particularly by leveling accusations against counsel of record and court employees who provide good faith assistance to, again, court employee being January, to provide good faith assistance to defense counsel cannot thereafter preside without creating an appearance of partiality the court must accuse. Section 5, outstanding questions created by the court's conduct. Based on all of the foregoing, many questions have been raised that create a scenario where the judge's impartiality might reasonably be questioned. Answers require an evidentiary hearing to obtain facts that would likely show that her impartiality is compromised. The questions are including but not limited to the following. Is the judge related to Patrick McCarthy-Neyman, right? Because she's Judge Kathleen McCarthy-Neyman. So that brings us to the point. Is she related? Yes or no? That needs to be vetted. That needs to be looked into. 2, why is the judge covering every hearing on this case through the trial? Is there a written order to that effect? Again, validated. Why is this being done? Is this typically done? Is this common practice? Right? Why is the judge covering every hearing on this case through the trial? Why aren't there other judges involved? Why did she repeatedly leave a civil session to cover this matter? Exactly. Is she, again, another gatekeeper like Judge Beverly Cannoni was in the Karen Reed case? Those are the questions I wonder. What specifically is in her complaint to the probation department concerning APCO January's actions? Exactly. What did he say? What was the problem? What was the issue? In what manner was January not doing what he'd normally do or report what he would normally report? 5, why didn't the judge disclose the existence of a probation complaint involving the defense on Ms. Fitzsimmons' own criminal matter? That's, again, questioning the judge. Why is not everything being disclosed? If everything's not being disclosed, that raises a lot of red flags. 6, why did the court have an ex parte meeting with ACPO January in his office? Why would this be done? What was the motivation? Is this common? Those are questions I asked. Number 7, why didn't the judge disclose the meeting and comply with the Code of Judicial Conduct? Right? You have to disclose the meeting. If you don't, then you're not complying with the Code of Judicial Conduct. Did the judge use any inside information obtained against Ms. Fitzsimmons? Great argument. Again, proof or unbiased. Why is defense counsel's advocacy perceived by the court as a manipulation or collusion? Why is this court using such descriptiveness, which are indicative of bias? Cumulative effect. The SJC has repeatedly emphasized that recusal analysis must consider the totality of the circumstances, even where individual factors might not compel disqualification in isolation. Their cumulative effect may do so. Here, the combination of negative pretrial findings, a personal economic interest, ex parte communications against defendant and counsel, prejudicial findings, and personal entanglements with probation and counsel would lead any reasonable member of the public to question the judge's impartiality. Public confidence in the judiciary requires recusal. Relief requested. Wherefore, the defendant respectfully requests that the court grant an evidentiary hearing, order the recusal of Judge McCarthy-Neyman, reassign this matter to a different judge by a means of reassignment not involving Judge McCarthy-Neyman, and grant such other relief as justice requires, dated February 8th, 2026, respectively submitted by Tim Bradel and Martha Coakley. Affidavit of counsel. I, Tim Bradel, an oath, do hereby depose and state under the pains and penalties of perjury that the foregoing facts stated in documents proffered are true and accurate to the best of my knowledge and information and belief. Signed, Tim Bradel. Certificate of service. He also verifies here that he served counsel of record to the ADA, James Gubitosi, by hand or email or first-class mail with all information. So again, he's disclosed. Unbelievable. Britt, you want Britt Mullen Law? You guys want to jump on the show and talk about this? You let me know. I'll send you a link. This is wild. I cannot believe this. I know Andrea Burkhart said online, I have still not followed this case hardly at all, but this Kelsey Fitzsimmons judge is so far out of line, she's a spear. I wouldn't be surprised if she recused ASAP to avoid evidentiary hearing on her highly unethical ex parte contact with the PO. Thank you for sending that to me, Paula. Jeez. All right, good. I'll get you a link. This is wild. Absolutely insane. I just cannot believe what the hell I just read. I just cannot believe I just read that. I mean, I just cannot believe what was in that. All right. Britt Happens is going to jump on soon. This is just wow. All right, no problem, Britt. Do what you got to do. No problem at all. Yeah, this is just crazy. I mean, that's what Mary just said. Thanks, MJ. What Mary says, I thought she's worse than Bev myself. I mean, I just can't get over all of this. You know, and again, it's the lack of disclosure. It's the behind the scenes factor of all of this that makes me sit here and question this judge's judgment. You know, I mean, just all these questions they ask. You know, this is just wild. This thing's taking forever to scroll down. All right. Jeez, I just cannot get over that a judge would do conduct behind the scenes communication like that, and not in any way disclose that to the defense. And you know, that right there tells you why she needs to recuse herself. Please smash the like. Yeah, thank you so much. Yeah, please smash the like and subscribe. Thank you, MJ. Leslie says, this started auto-playing after my last video, and I've had it on in the background. I thought it was a replay from something older, but said, holy crap, too many times. You have my full attention. Yeah, I mean, this is just nuts. Warwick's in the house. How you? Hope you're doing good. Britt Happens is going to be joining us soon. Welcome, Leslie. Thank you for joining. This is just wild stuff. I just cannot believe what I'm reading here. You know, and just every section of this. I mean, I literally, my head was exploding while reading this live on the air. I'm like, you have to be kidding me. Going behind the scenes and all of this is just madness to me. That's what I mean. I mean, that's why I say 2KY, that this is bigger than a recusal. This is bigger than a recusal right now, I must say. And this is no longer a matter of recusal. This is a matter of impeachment at this point. This goes beyond the need. I'm writing this right now on Twitter. This goes beyond the need for recusal. Spelling it wrong. There we go. One L, not two L. This motion by Breda Law Office was absolutely stellar. And I love these questions that they're asking. You know, it always tells me too that these defense teams, know about this stuff and are doing this homework behind the scenes. They were brewing this thing up. I mean, they might have been working on this thing going back months for all we know. That's all I got to say. They've been probably working on this for a while. And it's like we saw with Karen Reed's case. These attorneys are always more wise to this stuff. They're always working on this stuff. They're seeing this stuff. They're doing, you know, all this work in the background for a long, long time. You know, something was just completely off. That day they sent, and we watched this on Lauren Katie's fundraiser recently, the way she sent Kelsey back to jail that day, it just didn't sit right with me. And it wasn't just because I'm someone who believes Kelsey is innocent. I'm someone that believes that in her innocence, that she shouldn't have gone back to jail. You know, I said it many times in the show. Why were no alternatives ever optional for the defense team? Why was that never done? Why couldn't they have just done blood or urine tests? They never did that. And yes, her GiveSendGo is pinned to the top of the chat. They never did that at all. Why was that never done? Why did that never happen? It just made no sense to me. And now you're hearing that this judge was having communications behind the scenes. And then it's obvious she didn't get the desired result. January was forthcoming. You know, he said what he said. He gave an account of Kelsey's health the day before. And then the next day, when he was in that hearing, that emergency hearing, it was like she was against him. She was hard on him. She was hard on Bradel. And then she just storms right off. Right off. That's it. I mean, come on. Absolute insanity. That's all I have to say. It just didn't. I've never seen And as crazy as I saw things happen in the Karen Reed case, and there were plenty of moments that were crazy, let's be honest, there was a lot of moments with that judge where you're just like, what is going on here? But then the defense team comes out with this in this motion and says what they have to say, which is there's something not right with this judge. There's something not right with it. I mean, even if that judge, like they said, they say it here, right, number 7. Why didn't the judge disclose the meeting and comply with the code of judicial conduct? And that's a big question. Because even if the judge did go speak to January, why not disclose it? When it's done in secret, that now makes it seem like it's a conspiracy. It's this judge cannot be trusted. This judge must recuse herself. It's absolutely, this motion to recuse went so much further and so much deeper than I ever expected I was going to read today. And I had read, thank you, Julie. I did not expect, thank you so much, strange credulity. Thank you so much. In my opinion, this is witness intimidation of PO January. I mean, honestly, I don't think you're wrong. I mean, I feel like you have an argument for that. Thank you for the super chat, but I think you're right. I mean, that needs to be looked into. Why was this guy bullied? What happened in that office? If this judge is impeached, like KY Maverick was suggesting, is January going to be interviewed? Is he going to have to testify about what happened, what was said? Was the judge using a bullying demeanor? I don't know. We can speculate, but I don't know. But this is wild, to say the least. I mean, this is just absolutely. I was not expecting to read something going this far. I was expecting something more along the lines of the judge was wrong to send her back to jail. But now it's like you read this and it's like, this is far beyond what I was anticipating. And I was almost speechless at times reading this. And like I said, is the judge related? I'm going to guess that probably not. But I mean, McCarthy's a very popular name. I mean, let's be honest. It's not a rare name. McCarthy's popular, popular name, but it has to be vetted. It has to be researched. We have to know. It has to be called into question until it's proven otherwise. There's no denying that at all. And Scott says, agreed, KY Maverick, regardless of the outcome of this prosecution, what is at issue now is all that has already happened, now happening before trial even begins. Right. This cannot go to trial under this judge at all. This is madness. I mean, I'm tired of what I'm tired of in these cases is I'm tired of a defense making arguments like this. Like, this is unprecedented. This is uncommon. This is whatever. And then nothing happens. And that's what I'm worried about. I don't want to see Kelsey and her defense team in a situation now where this judge absolutely has to recuse. This, like I said, this was more information than I expected they had at hand. But I cannot see in any way, shape, or form how this judge could preside over this case in good conscience, given that there's been obviously cited violations as by the defense team of Kelsey Fitzsimmons in this motion. And they've cited a lot of law here. And they've even gone as far as citing her residence, North Andover. And so McCarthy-Neyman, right, is her what is it called there? It's her maiden name. Her maiden name would be McCarthy, right? So, if that's the case, then it could be, it's not uncommon for people with the same last name to live in the same town. I mean, I grew up with people in my own town that had common last names, and they would, not be related. Say, oh, you guys were related. There were two people two classmates I had both had the same last name. We'd always joke they were cousins. They're like, no, we're not related because they look different. Their personalities were different. And that could be what that is here. It could just be, it's a common last name. I'm sure if you look at any town and you're going to have common last names, Jones, Johnson, Jackson, you're going to have, we have a McCarthy right here, for goodness sakes. Welcome, Sharon. Are you related? Are you related to the judge? Are you related to the cop? But no. It's all some things that could be, I would say this. They're probably not related, but they could be. And they could be until you find out that they're not. And that's how I look at this. This has got to be looked into. Is the judge related to Patrick Noonan, McCarthy-Neyman? That has to be looked into. No question about it. That cannot stand without any level of lack of validating. No problem at all. No question at all, I should say. All right. So then, that needs to be looked into. But like I said, I'm going to say a low percentage chance they're actually related. But again, always vet, always research, always find out if that's actually true or not before going. You can't not pay it no mind. It's got to be looked into for sure. So I'm already seeing some of these posts on Twitter, getting some responses here. Two people are saying, why didn't one of the first comments on Twitter, why didn't the judge disclose that she met with the PO at the hearing? Exactly. Someone says, who's going over this on their podcast? Me. I'm going over it right now. People are not used to me being live on Mondays because I usually work today, but post Super Bowl day off from work, usually how I spend my day. So this is an incredible story, to say the least. And someone said, would the probation department file a complaint against this beast? I hope they do. I don't know what their steps are there, what they can and cannot do, but at some point, I'd imagine there's going to be an ethics complaint about this, and we're going to see where that ends up going. But it's like I said, this is far more than I expected. A lot more than I expected. This is shocking information, and we're standing by for Britt Happens here in just a few moments. Since she's able to make it on, she's getting set up. There's a nice picture of Kelsey today and her family, and someone that got to meet Kelsey. Here we are. Let's get that image on the screen for you guys. All right, we'll share this tab. Here's a picture of Kelsey today. Zoom in a little bit. Let's see what we got here. And there's Kelsey today with her family. This young lady here had her picture taken with Kelsey and posted it online. So it's nice to see good supporters out there today. Wish I could have been there. I heard the hearing ended up being really short, but Kelsey looks very strong here. She looks like she's upbeat and definitely recovering. And the woman that made the post said, I just arrived at Essex County Superior Court in Salem to support Kelsey and her family during the discovery compliance hearing this morning. Kelsey and her family agreed to let me take their photo a few minutes ago. They are in good spirits and they are standing strong. So that's good to see. Good to see Kelsey, again, in good spirits and everything right now. So as they take this on and push through that, we got to stand with January. I mean, like I said, I didn't see anything with him when he was in court that day back in September. I felt he was very honest. He was really defending, Kelsey's ability to take that test, and like, hey, she's taking it, she's in pain or whatnot, but there was really no issues, that he was reporting. It wasn't like she's refusing to take the test, or she physically cannot take the test. It was just, she physically is in pain and is struggling, and that's the bottom line. So there's really nothing more to that than that at the end of the day. And Britt Happens is here with us. All right, Britt, let me get this thing. Let me turn my volume down.
Hello.
How you doing?
Super. Can you hear me?
Yes, I can. It was so loud I had to turn my volume down a bit. All right, you're good.
I'm so sorry. I'm using kind of a different setup than I normally do. So here we go. Right. Let me turn my mic down.
I should go off screen for 1 second.
Okay.
Okay, I'm back.
Bluetooth and devices.
Hey, audio sounds perfect.
Oh, well. Okay. Yeah. All right. I'll just speak kind of quietly.
You're good.
Oh my goodness. So I'm in complete shock.
Yeah.
Again, I mean, it seems to just happen all the time when we look at these Commonwealth cases, but right. You know, what surprises me the most is that this was just one day before the hearing. I mean, one day before the hearing, McCarthy-Neyman was in communication with probation, and you know, whatever caused McCarthy-Neyman to place such a complaint, which, you know, I have no idea what the complaint was. It doesn't say in the motion to recuse what that complaint was about, but I will say it sounds a whole lot like all Kelsey was doing, or all Kelsey's attorneys were doing, was trying to communicate the difficulty that she's been having with her health. So, you know, right. What on its face is McCarthy even saying that, you know, that the issue was? I'm just so confused about what her argument would even be with this.
And then, you know, like Brito went in there. It's like, she's not, you know, because early on, I'm like, I thought she wasn't able to take the test. And someone corrected me and said, no, Mazza, this was months ago. She was successfully taking the test. When she was home, she was taking it. They called the hearing simply to say, Your Honor, she can do it. She's struggling with it. And this judge just went off the rails and sent her back to jail right up through Christmas. And it was like, what was the justification in that? This is a crazy story that's gotten crazier now.
It has. And the last time that I ever saw, you know, any kind of judge having ex parte communications with, you know, anybody, especially when the defense is the ones who are being left out and they're the participating party, it is taken very, very seriously. The last time I saw that was in Georgia with the RICO, YSL, what's that rapper's name? Young Thug, that Young Thug trial. And that turned into the Supreme Court in Georgia removing the circuit court judge, or, you know, that particular judge who was asked to recuse himself. He said, no, I won't. And then he was called out in open court about the ex parte communications. And the way that judge responded was pretty much in a way that I would expect to see from McCarthy-Neyman, which is, you know, how did you find out? Who told you? Not, you know, taking any kind of accountability for his own actions. It was more about, well, how did you find out about my behaviors? You know, it was just, so I'm hoping that, you know, I'm really hoping that this is taken as seriously as, you know, the last time I saw this. So.
Yeah. Looks like KY Maverick is quoting Betterow there on some of his thoughts, and that this motion, obviously a colleague, of Tim Bradel. This motion 100% must be granted if the judge had investigative ex parte discussions and then tried to conceal that fact, Attorney Mark Betterow said. That's coming from a great attorney right there, and every attorney is obviously outraged with this that has any kind of ethics whatsoever, like Betterow and a lot of great attorneys like Mullen Law do, that see something like this and are in absolute shock. This is insane. Actually, he goes on further here.
Go ahead.
He said, yeah, thank you. This is what he wrote on Twitter in full. He said, motions to recuse a judge are rarely made and even more rarely granted, if for no other reason than that the judge at issue will rule on it. You will be stuck with the judge you tried to toss, and denial is seldom something that will be reversed. Having said that, this motion 100% must be granted if the judge had investigative ex parte discussions and then tried to conceal that fact. More than recusal, this is the sort of thing that can result in front of the Commission on Judicial Conduct, can result in, let me just repeat myself. More than recusal, this is the sort of thing that can result in front of the Commission on Judicial Conduct. Ex parte communications of this sort are a major no-no. Yeah, that's huge by Betterow right there. And that's actually in response to my post that looks. Wow. Sorry, but it looks like we lost you.
Oh, no, I'm here. Okay, so my question for either Mr. Betterow or, anybody else who deals with this every day would be, is it common for defense attorneys to communicate with the probation officer of their clients? Because, if it seems like that's something that probably is commonplace. Just to make sure that you are in compliance with, whatever you're supposed to be doing if you're on bail. So I don't see what McCarthy's complaint is to be such a big deal. With speaking with a probation officer as a defense attorney is probably something that happens all the time.
Right.
That's the way I see it.
Right. As an attorney, and then when you look at the judge, it's like, like even at the end of this motion, it's signed and certified by Bradel that he has informed Gubitosi of this, with the ADA. I have served counsel of record, ADA James Gubitosi by hand. So this motion was sent to him. So any kind of motions, conversations, anything like that is shared. And with this, you have I just never heard, like I've heard of defense attorneys interviewing witnesses. I've heard of prosecution interviewing witnesses. At least, unless I'm maybe uneducated to this or not aware of this, I've just never heard of a judge doing this. And even if the judge did that, and that is commonplace, saying I'm just wrong or just uneducated in that aspect, then ultimately they make the ultimate point, because they ultimately say here, why didn't the judge report this back to counsel to inform them that this happened? And then the next day they proceed to have like he says here, why didn't the judge disclose the meeting and comply with the Code of Judicial Conduct? Did the judge use any side information obtained against Ms. Fitzsimmons? That's where the collusion comes in.
Exactly.
The feeling of collusion potentially.
And here's the other thing. So if a judge recuses oneself, it's not a black mark on their record at all. It happens all the time that, people are brought into court. Turns out the presiding judge knows the defendant or, has some kind of connection with the attorney assigned. And in those cases, the judge will very commonly say, look, I have a conflict of interest. I need to, sit this one out. It is not a black mark on your record to recuse yourself. And so when you have a judge who fights to remain on the bench and stay as the judge presiding, that's a bad sign.
Yeah.
A very bad sign.
This is just mad. I mean, it's just, and like I said, it's the fact too that when all this is happening, when all this is going down, this conversation that's never reported, that judge the next day, it's not like, for example, like court happened the next day and the judge just came in and said, well, she's still going to do the scram device, but she's going home. When you see the fact that she actually sends her back to jail, walks out of the courtroom, disrespects Bradel as much as any judge has ever disrespected any judge that I've seen through the cases I've followed in recent years, then you look back at this ex parte and you say, oh my God, this seems like, I mean, at this point, the tinfoil hats are coming out for conspiracy on this now.
And understandably so. Yeah. I mean, this is the kind of thing that feeds the conspiracy theories. It's the kind of stuff that makes those theories not seem so out of left field. This is the kind of stuff that, only serves to drive more of a wedge between government officials, county officials, local government, and the public that it's supposed to be serving. So hopefully whatever's done next is something that will, maybe put a bridge there and, help the public to have more trust in the Commonwealth.
Absolutely. And then how soon into the day did you hear about this today? I kind of slept in today because it was the post Super Bowl.
Yeah, I did too. So yeah, I honestly, so when I first woke up, I was just kind of doing laundry and listening to a completely different case that Melanie Little has been covering, listening to a different trial. And then somewhere around lunchtime, I heard that a motion to recuse had been filed and that Kelsey was having a hearing today. So, the first thing I watched was the appearance that Bradel and Coakley made with Kelsey and Courtney before the public right after the hearing. And then I saw that you were going live. So this was my first vision of the motion, so to speak. But
well, yeah.
So yeah, this is fresh for me, blind read.
Yeah, it's like I said, I woke up a little late and I'm like, I pondered going this morning and I woke up and I was like exhausted. I'm like, yeah, this is why I was taking the day off after the Super Bowl. I'm like, I can't make that. So why? It's like an hour and a half for me to get there.
Sure.
I just said, I think I'm just going to sleep in today and, I'm going to try to get the trial, obviously. But when I heard about this, because I knew about the motion yesterday, obviously it was being reported on in the evening. And I was like, okay, here it is. And then it came out today. I was actually getting ready to locate it. And Glamma Suze, thankfully, had already posted it and tagged me. And she's like, here it is. Here's the Google Drive. So I thank Glamma I got to make sure what I'm doing here is I'm saving these PDFs because you know what I've done a lot over the past couple months? I've tried to reference back to these PDFs and I don't save them. So like today I'm saving these files. I'm keeping them, that way I can always refer back to them for information because these cases are so deep. There's so much information and you forget facts.
True.
Yeah.
I mean, it's good to have that web of knowledge, have it quickly available and on hand, because I mean, you've seen it with the Karen Reed case. You've seen it with many other things, I'm sure, but you will be gaslit. I mean, the public will be treated like we don't know any better all the time, and in fact, this would not be the first time a document swap. If we see one in this case, it will not be the first time that we've seen one either. So saving those PDFs the way that they are when they're first filed is another important thing to do. That's why we take screenshots, isn't it? Because people do delete things, people do change things. So I'm glad that you're saving. I'm glad you're saving them in the way that they are right now.
Yeah.
But thanks so much for your coverage on this. I'm going to get back to, doing my housework, but man, I was shouting in my house when I first heard this. She needs to go. I mean, it's well past time. Even before today, the vast majority of the public felt that, it was time that she left. All that counsel needs to do is show that there's reasonable doubt in a judge's level of impartiality. And I think that Bradel has more than met his burden there. So hopefully we get the proper the proper action after this. But I'm going to get back to it. Thank you for having me on. You guys have a great day, and free Kelsey.
Take care, Britt. Thanks for coming on the show briefly. We appreciate you. Have a great day.
You too.
All right. Britt Happens, ladies and gentlemen. Making a brief cameo here today on the show. I appreciate her stopping by. She'll be joining me on the next Kelsey Fitzsimmons fundraiser, which will be occurring on the 15th, this Sunday at 2 p.m. We're going to do another Kelsey Fitzsimmons fundraiser. We're going to be talking a lot more about all of this as well. So that's it. The fundraiser that they did for Kelsey, the Super Bowl squares, raised quite a bit of money too. They raised $1,900 for Kelsey's defense fund and medical needs off the Super Bowl squares. So that is that. So, ladies and gentlemen, that's my show. Special Monday appearance here. Nice vacation day from work, the day after the Super Bowl, and just using some time here to talk about this explosive new material that came out. So subscribe to my channel, like this video. I'll definitely be back next Sunday with the Kelsey Fitzsimmons fundraiser. From MazzaMedia, I'm Mark. What's Justice Served tonight? They're going to be talking about that at 6 o'clock. And we will be back later this Sunday, for a Kelsey Fitzsimmons fundraiser. From MazzaMedia, I'm Mark. Ladies and gentlemen, take care of yourselves. Bye-bye.